Next case will be Pucci versus 19th Judicial District Court and Chief Judge Mark Summers.
May it please the Court, and good morning. My name is Joel Sklar.
Would you please wait till we clear the room, please?
Oh, forgive me, Your Honor.
Okay. You may proceed.
Thank you very much, Your Honor. Again, good morning. May it please the Court. My name is Joel Sklar. I'd like to reserve 10 minutes for rebuttal if possible. As the Court knows, this case is going on since 2007. I've had the absolute privilege and honor of representing Julie Pucci, who was a Deputy Court Administrator of the 19th District Court, who was terminated by Chief Judge Mark Summers pursuant to his powers and authority as Chief Judge as a Deputy Court Administrator when he reorganized the court back in, I believe it was 2008, 2009. This case went to trial. We prevailed in federal court on a Section 1983 claim. The claim was based on a First Amendment retaliation claim. Specifically, Ms. Pucci had spoken out to the State Court Administrative Office about Judge Summers' use of religion from the bench. At that point, Mark Summers began his reorganization process afterwards and terminated her employment when he eliminated the position of the Deputy Court Administrator. The jury provided a verdict on the First Amendment claim as well as a 14th Amendment due process claim for Mark Summers' failure to provide her a meaningful due process hearing. Shortly before trial, around 8 or 9 days, Mark Summers had, pursuant to his authority as a Chief Judge and MCL 691-14081, adopted an indemnification policy for the court that essentially said if there are any settlements or judgments entered against court personnel for employment-related decisions, the court will assume the obligation to pay that judgment.
But counsel, the question I have though is that this was still done during, in terms of before we get to phase 2, phase 1 is that this was still done during the reorganization process of the court, correct?
Correct. As far as the termination?
Yes.
Yes, absolutely.
And whether the
correct.
termination was handled correctly or incorrectly, it was done in terms of the reorganization, right?
Absolutely it was. And that was, there's no issue about that. In fact, Mark Summers had consulted with the State Court Administrative Office when he implemented the reorganization plan that was first developed and designed by his predecessor, Judge Leo Foran. So yes, to Justice Bernstein's question, absolutely. It was an elimination of a position pursuant to reorganization. The power to reorganize the court stemmed from the Chief Judge Rule MCR 8.110. And that resulted in the elimination of Ms. Pucci's job, and then the lawsuit followed, and the judgment was entered back in June, or actually June 30th, oh my God, of 2011 is when we got the verdict. It's been some time. And so it is our position, essentially, that when, after Judge Summers issued the indemnification policy, the city opposed it in federal court. There were federal collection proceedings. At that time, the 19th District Court was represented by other counsel. Other counsel joined with Julie Pucci in the relief sought, which was to enforce the indemnification policy and to compel the city to pay. The court said it had no jurisdiction. We came back to state court, domesticated the judgment, and here we are now. We had presented this issue to the Court of Appeals, as the court knows. The Court of Appeals agreed seemingly with every argument that we made and rejected every argument that the 19th District Court made. At that point, the 19th District Court was represented by the same attorneys representing the city. The Court of Appeals' decision was that a chief judge could, in fact, utilize his powers and indemnify court employees for acts in their official capacity, but not when the judgment was rendered against them in their individual capacity, as it was in this case. That was clear error. Under bedrock principles of 42 U.S.C. 1983, judges and state actors, police officers, teachers have personal liability, specifically because of their status as state actors, precisely because of their official acts. Does a state actor have individual liability under Section 1983? And so when we analyze this case, we look at the statute. What does MCL 691-1408 say? What it says is that whenever a judgment is entered against a state employee, a governmental agency, of which the 19th District Court certainly is one, may voluntarily agree to assume that debt, to assume that responsibility for the judgment. That is what the 19th District Court did here, not only through Judge Summers, but also through his successor, Chief Judge Richard Wygonick, who during the federal proceedings specifically provided an affidavit that said that the court would indemnify Judge Summers for the Pucci judgment. The Court of Appeals seemed to both misunderstand how Section 1983 works, what individual liability means in relation to the official acts of the state actor, and as I believe, misread the statute. MCL 691-1408 is very clear. It has really two criteria. It allows the governmental agency to indemnify when the damage flows from an action by that state actor in the course of their employment within the scope of their authority. Here, you can, this case, and it's, I think it's a matter of law by the Sixth Circuit who affirmed the verdict, there can be no question that Judge Mark Summers was acting in the course of his employment at the time that he decided, as Justice Bernstein noted, to reorganize the court. He was acting as chief judge. He was utilizing his powers that this court has provided him under MCR 8.110, 2B, and 2C.
Counsel, let me ask you a question. If Chief Judge Summers and his successor, Chief Judge, I don't remember the name of that person.
Judge Richard Wygonick.
That person. If they believed that the agreement created a financial liability that was to be covered by the court, why does neither the judgment or the indemnification agreement ever show up on any of the annual financial audit reports that the court files with the Department of Treasury? Every year since then, the court's filed an audit report. It's publicly available. You can pull it up at the Department of Treasury's website, and never does it mention either the indemnification agreement or this judgment as if this is something the court is supposed to pay. Why not, if they were in charge?
You know, that I can't tell you. I don't know who on behalf of the court at the time of the indemnification filed those papers.
Plant Moran.
Well, where the heck are they? So Plant Moran would be helpful to be here. I don't know why the accountants didn't treat that as such.
Well, Plant Moran, in its report, says that it is speaking for the court management. I assume you think the chief judge is court management? I
have no doubt that the chief judge is the director of the court, is the chief administrator, the chief manager of the court. Why it's the CPA failed to list the judgment as a liability and the indemnification as a liability, which I think is what I'm hearing from you, Justice McCormick, that I cannot respond to. There's no question as a matter of law that it is a liability. There's no question that the court's willingness and voluntarily agreement to accept responsibility for payment of the judgment is a liability. Why the paperwork that was filed with the state doesn't denote that I cannot answer. I was terrible at math. I'll never be a CPA. I'll never be a doctor. That's why I'm a lawyer. And so here I am telling the court that I simply don't know the answer to that question.
Does the funding unit have any say in the extent of the obligation that the court is trying to impose on it, or do they just have to write a blank check?
Justice Viviano, I think that that is the position by the court and the city, that the city essentially has a preemptive veto power over a court's decision to adopt an indemnification policy for judgment as this case. I think the answer is no. The city does not have standing to object, and I'll tell you why. In this case,
let's set out the ground rule. So the court has to propose a budget of some sort, either a line item or a lump sum budget. I'm not sure which one was done in this case. I'm not sure the record reflects that, but either way, the city has to approve the budget, right, for the court?
The city has to approve the budget for the court, but the court
doesn't fund itself, right?
The court does not fund itself. That is true. The local funding units have an obligation to fund the court. But I think...
So most circumstances, putting aside indemnification, if the court wanted to expend large sums of money, it would have to either be included in the annual budget, or there'd have to be some type of supplemental appropriation, right?
It would depend upon that liability. There are certain liabilities that are imposed on the court, or that the court accepts, which do not go through that process. And I'll point the court to the Cameron case, which I believe is I thought it was a 1998 case by this court, where there is a judgment entered against a court. The Cameron court said that it is the obligation of the taxpayers to pay for that judgment, because a judgment resulting from an employment practice is a necessary expense of administration. It did not indicate that there had to be any sort of preemptive right of the funding unit to say no to that obligation. But let me go one step further.
Let me just jump in there, because isn't that case that you described, that I haven't looked at yet, but certainly will, distinguishable because the judgment here was not against the court?
I think the case has that distinction, but I'll tell you why. I think it's a distinction without a difference. In this case, what the 19th District Court is doing, or what has agreed to do, is accept an obligation. And that is all. How that obligation gets paid, and I think that's what your question is, how does that obligation paid? Well, there are different ways. One, there's never been any evidence offered in this court that the 19th District Court cannot pay that amount from its already existing budget. It hasn't indicated that, it hasn't presented evidence to that effect. Secondly,
then how do you have transparency, though? If they can just simply do this, you're talking about $1 million. I mean, how do you have any kind of transparency in terms of what the court's doing and how the court's doing? And I get that we're an independent branch, but there still is a funding unit, isn't there? And
there is a funding unit, but there's transparency here because there's nothing surreptitious. Here's the indemnification policy. The policy is a public document. There's nothing secretive about it. But there's an answer to that question. Let's assume that the funding unit and the city, once this court finds that, yes, a chief judge can, on behalf of the court, indemnify a court employee, be it a judge or court administrator, for such a judgment. At that point, there is an administrative order that is already set forth, Administrative Order 1998-5. Once that obligation arises, once that obligation is validated, at that point, the 19th District Court can request funding from the funding unit. The funding unit can say yes or no. If there's an impasse, Administrative Order 1998-5 allows a means to resolve that, both through mediation and the filing of litigation if necessary.
Shouldn't that be done before, though? Shouldn't that be done like before this issue arises? Like if I'm part of the funding unit, shouldn't I be able to kind of set forth some of the guidelines that are going to determine how the court's going to function and operate, not in terms of decisions it makes and not in terms of doing anything that's going to impugn on its authority, but just in terms of issues like this, with their sizable issues? Shouldn't the funding unit have an ability to budget for that and then ultimately determine that?
No, I don't think so.
Let me supplement the question, too, and also decide whether, for example, depending on the amount of the exposure, how much exposure it's willing to take on and how it's going to deal with that exposure, either through if it's self-insured in some fashion or go out and procure an insurance policy.
Well,
any type of responsible risk management sort of goes out the window if we agree with your side.
I disagree with that, and I'll tell you why. The decision of risk management for court employees is the court. There is a separation of powers doctrine. In Judicial Attorneys Association, this court was very clear that all management of court personnel, all administration of court personnel falls within the exclusive realm of the judiciary. Now, certainly, the court has to take into account funding issues. But as Judicial Attorneys Association stated, that does not tip the scales. Autonomy and judicial autonomy is meaningful. It's meaningful because judges must make decisions about court employees. In making those decisions about court employees, judges must manage risk. That is part of their job. The State Court Administrative Office tells them what they can do. It says you can indemnify pursuant to MCL 691-14081. You can procure insurance pursuant to 691-1409. There may be a situation where you procure insurance and perhaps the limits of liability are exceeded. Perhaps the carrier goes bankrupt. Perhaps there's an exclusion that doesn't provide coverage. At that point, it is the court's decision to determine whether or not to indemnify, not the competing interests of the funding unit. Here, the funding unit and the court have diverse interests, and that's reflected in concrete terms in this particular case. We know that because the court initially adopted the position of Julie Pucci in the federal case when it had a different law firm representative. It was Robert Harrison, I believe. When the case came to the state level, the city utilized the same law firm representing the court. Now, that to me reflects that there are conflicts here. The only way the conflict can be resolved is if this court affirms the autonomy of the judiciary, of its chief judges, to administrate its courts as it sees fit, and part and parcel of that decision is going to be the decision to indemnify in cases just like this. I'll also note for the court that I think the answer to every question we have leads back to the statute. In this particular case, the state legislature has already said that governmental agencies have their own discretion to determine whether or not to indemnify for a judgment as long as that judgment results from an act that occurs in the course of employment and the scope
But
of
counsel,
authority.
once you get past kind of the initial cost that it takes to run a court and to dispense justice, does the funding unit have any ability to determine how the court ultimately runs as it pertains to funding, or does ultimately the court itself, can it determine, well, you know what if the court determines that it wants to do just certain things within its budget that don't necessarily go to the determination of justice, but it just wants to do those things? Is there any point at which then the funding unit would have any authority to correct that process?
Well, I think it depends what the court is doing. If there's something that is unconstitutional or
No, it's constitutional. Let's just say it's wasteful.
Well, I'll respond to that. If the court has its own budget that's only been administrated, the court can administrate it as it sees fit. And we have that case. It's an unpublished decision by the Court of Appeals in the O'Neill versus City of Dearborn case. So the answer is no. Once the money's been budgeted and the court has the autonomy to administer budget as it sees fit, which is what at least the unpublished decision has said, the city does not. But if the city is concerned with funding, if there is a second budget request asking for certain monies and there is an impasse at that time, again, the remedy is set forth in the Administrative Order 1998-5. And in this particular case, that is not where we are. The issue that the court asks us to address is whether or not the 19th District Court could assume an obligation of another, specifically Judge Summers, and the judgment entered against him for his work-related constitutional torts.
Mr. Sklar, I have a threshold, what I see as a threshold question. Chief Judge Summers is no longer the Chief Judge, and Chief Judge Wygonik is no longer the Chief Judge. And even assuming that the original indemnification agreement was valid, and I have nothing in particular with which I disagree with you in that regard, but even assuming that the original indemnification agreement was valid, why does the current district court remain bound to that agreement? Obviously, they don't seem to agree with that agreement anymore, given their involvement in this case. You argue in your brief that the district court remains bound pursuant, that the new chief judge remains bound to the indemnification agreement exclusively pursuant to this court's decision in Toussaint. My understanding is that Toussaint was focused on the question of wrongful discharge. It's never been expanded beyond the area of wrongful discharge. There's been considerable support for making that explicit on the court, but that's never been done either. If not, why should we extend the Toussaint doctrine to apply to the context of employment and indemnification? And is that your exclusive basis for arguing that the court must remain supportive of the indemnification agreement? It's the only thing you seem to focus on.
In our principal brief, I don't believe I do. In my reply brief, I don't believe I referenced Toussaint. I believe Toussaint was referenced below, but I'll answer that argument and I'll tell the court
why. Why can't the current chief judge decide that he doesn't want to abide by that indemnification agreement any longer?
I think that's a very fair question. One, at the time that the garnishment was issued, there was no rescission. There's actually never been a rescission. There was no rescission of the indemnification policy. There was no rescission of Judge Wygonic's decision to indemnify. And so once that garnishment is issued, everything freezes. You can't then subsequently change your mind and say, well, no, I don't want to pay it. Secondly, if you look at Judge Salome's testimony, what he testifies to is in support of the indemnification policy. What he actually testifies is that if a judge has a judgment rendered against him for business related to the court or for violating an employee's constitutional rights, that the court would indemnify. And the court, hasn't had that issue, but that the court would indemnify. He doesn't disagree. And again, this, I think, brings us back to some of the more, I don't know if it's nuanced, but some of the underlying issues of this conflict issue. You have a chief judge who testifies, I think, relatively clearly that the court does indemnify exactly for this type of conduct, exactly for this type of judgment. And yet, perhaps reasons that I'm unaware of, political, I don't know, has been willing to allow the funding unit to dictate what the court will do in this particular case.
Is the funding unit a necessary party in this action?
No, they are not a necessary part of this action. If they were a necessary part of the action, they would have intervened. They have been required to be a party in the underlying case. They were not. And the reason they weren't is because the city, the funding unit, has no control over employees. They have no control over the management of the court. They have no control over the administration of the court. That is the chief judge function, which goes to the ability of the chief judge, pursuant to the express and unambiguous language of 691-1408, to adopt an indemnification policy for this.
It's not about managing employees. It's about the indemnification provision that was put into place.
Correct.
I think that takes us back to Justice Viviano's original question. Doesn't that require budget approval?
No, it does not. The statute doesn't, if the court is bound by the statute. This court has for many, 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 many years told us that they are textualists to an extent that we read the express language of the statute, we abide by it. We are not the legislature, we are the judiciary. We understand our independent function. Here, the statute says that a governmental agency, of which the court is that, may agree to indemnify an employee who has a judgment rendered against him or her that arises out of the course.
That's putting the cart before the horse, though. That the court can indemnify doesn't necessarily put the funding unit on the hook, does it?
Well, I believe under Cameron, it probably does put them on the hook if
more to the point, it doesn't. The fact that under the statute they could indemnify the employee doesn't tell us how it's done. That's the whole question. What's the way to do this?
The issue is how does it get paid?
Yeah, well, I'm all for responsible risk management, but signing a document on the eve of trial that obligates seven-figure obligation to the funding unit without ever consulting them, I'm not sure qualifies.
Well, I think that the court is reading more into the statute that exists because the statute speaks for itself and tells us what a governmental agency can do.
Tells us how a government agency should go about doing that?
It doesn't need to. It tells the governmental agency that they have that right. It tells the governmental agency that they can make that choice. It doesn't tell the governmental agency that one branch, the judiciary, has to go to the legislative branch to get pre-approval. That it does not say. If the legislature, who certainly contemplated the courts were going to be involved in indemnification decisions.
Even though it involves money, which generally comes from the legislative branch, appropriations, in this one instance, the court is unto itself. It can fund itself. It can expend funds it doesn't have. It can obligate third parties to unlimited liabilities. It just, because of that statute that says the court can, or any government agency can provide this coverage, that you're reading in that the authorization for the chief judge, isn't that quite a bit of power? I mean, if we were looking at the legislative branch or city council or at any level, there would have to be a vote, right? You'd have to have some type of vote. There's different protocols in place.
I'll be happy to answer.
Here, the budget process accounts for that, right? The court submits a budget, the legislature appropriates it, they fund the court, and on we go from there. But here, your position puts an immense amount of power into the chief judge, doesn't it?
Well, this court has appointed chief judges to exercise the power that they have. And this court, has authorized chief judges through the court rules to make these difficult administrative managerial decisions and adopt these types of policies. That's what the State Court Administrative Office has told chief judges they are supposed to do. In this case, the Michigan legislature, in drafting the statute, has determined that be they a court, be they a city, be they another governmental agency, that governmental agency can make that call. And here, the chief judge is the only person who can speak on behalf of that district court. The issue of the acceptance of the liability, I would suggest, Justice Hara, is the first issue that has to be decided. First, whether or not the court will agree to pay or assume obligation for that amount. The second question is the court going to pay from its existing budget? And again, here we have no evidence that they don't have the means by which to do so. There is absolutely no evidence that the court can't pay it out of its existing budget.
So, Mr. Sklar, I would be wrong to assume that by virtue of the court's position in this case that it no longer wants to indemnify.
Oh, I think that the position put forth by the court is that it does not want to indemnify. I think that the state...
And so hard decisions can be made by chief judges, as you've just said, but that doesn't apply to the current chief judge. It only applies to the chief judges who have chosen to indemnify.
No, I would put to the court that applies to the chief judges within their power.
Why can't I assume that the new chief judge has decided not to indemnify and that the only legal argument that you have in opposition to that position is the Toussaint argument?
It's not just the Toussaint argument. It's also the legal effect that once the garnishment is issued, that obligation is frozen. That policy was not...
Isn't that essentially saying the Toussaint, making the Toussaint proposition without making
they're close in hand.
Toussaint?
I agree. They are close in hand. But we have a situation in which there is the reasonable expectation of the policy at the time it's made. We certainly have that the garnishment is issued, which freezes those obligations at the time that they exist. We have the words, I think, of Judge Salome, the testimony of Judge Salome, which states clearly that the court is responsible and will indemnify for a constitutional violation visited upon employee.
But you acknowledge it no longer wants to indemnify.
Well, I acknowledge that's the position in the brief. I don't acknowledge that's what he testified to. And I think that his testimony is why there is no trial court found no issue of fact. In fact, I think if you look at the words of Judge Salome and what he testified to, the obligation continues. It would make little sense to me if an obligation can be made by Chief Judge Summers, then by Chief Judge Wygonek, who has no personal stake or outcome in this case, a garnishment issued on a policy that has never been revoked or rescinded, and then subsequent to that decide, well, we're not going to honor it anymore.
I just ask you one more time why you're not making a Toussaint argument and why Toussaint should be expanded by this court.
Well, I think Toussaint should be expanded really because under the theory that it's essentially a third-party beneficiary theory in Toussaint. There are reasonable expectations that are made that the employee in Toussaint is led to believe that these exist. You have the exact same argument here, especially with the clear and unambiguous affidavit of Judge Wygonek. Once that promise is made, and once that promise is stated, that the court will cover the judgment entered against Chief Judge Summers, at that point under Toussaint and a third-party beneficiary.
You think the Toussaint argument, by the way, has been adequately ventilated thus far? When you had, I think, a half-page statement to that effect, and the other side had about a three-quarters page analysis.
Right. If it wasn't, that is my error. But I think the court can ventilate that issue. I think that issue, again, has been raised both in the Court of Appeals and the trial court, and it would seem to be, under the third-party beneficiary statute, quite frankly, completely wrong to allow certainly Chief Judge Wygonek to make this unequivocal promise and then be able to, the court for which Judge Wygonek binds, then to back away from it. It would make very little sense to me. It would be grossly unfair. And I would ask that the court not adopt such a position.
Let me ask you about something that has even less ventilation.
Go ahead.
Is a 1983 action, in this case, is it an action for personal injuries?
It is.
Why?
There is a case, Piffus versus Carey, which is a U.S. Supreme Court case which talks about Section 1983 cases. A Section 1983 case, it has its own is a constitutional tort. The way, what I put in my brief in a footnote is when courts have determined what statute of limitations applies to Section 1983 cases, the courts will look to the personal injury statute to determine that, because constitutional torts, they're intentional acts, they're most akin to personal injury cases. That's how they've been treated. That's how the Supreme Court has treated them, and that's what they are.
That the U.S. Supreme Court has treated them that way, does that give us any guidance as to how our legislature used the words under the Governmental Tort Liability Act? Civil action for personal injury?
Yeah, I believe that the legislature intended to cover judgments just like this, and the court can look to what courts have done before. Beebe versus Wilson is a particular case where 14081 was utilized to indemnify a police officer who had shot somebody pursuant to Section 1983 case.
But someone who's shot certainly has experienced a personal injury, haven't they?
Well, Ms. Pucci also experienced a personal injury. Remember, she was awarded emotional damages of well over 6 figures in this case. Her injuries were not only economic, they were also personal, and that's reflected in the verdict that she received. Any other questions?
All right. Thank you, Counsel.
Thank you very much.
Mr. O'Brien.
Good morning, Your Honors. Dave O'Brien on behalf of the 19th District Court. It may be a little unorthodox, but I actually want to start off my argument this morning by conceding a number of points on indemnification to help distill this case down to what I think is really in dispute. First off, we concede that district court employees can be indemnified for judgments entered against them. We also recognize that the power to indemnify can extend to judgments entered against court employees in their individual capacities. And we don't deny that a court employee can even be indemnified in appropriate circumstances for violating somebody's constitutional rights. The real issue at the heart of this case is much more basic than any of those points. The key issue is who has the power to make indemnification decisions with respect to a district court. And more specifically, does a chief judge have the unilateral authority to indemnify himself against a personal capacity judgment without any checks or balances in place to protect against abuse? And there are only two potential sources for that unilateral power. It's either the indemnification statute or the chief judge rule. And we don't believe that either one of those authorizes the action that Judge Summers took here. So let me start with the indemnification statute. It basically says that a governmental agency may indemnify its employees for actions taken within the course of their employment or within the scope of their authority. Now, plaintiff says that the 19th District Court is a governmental agency, and she's absolutely correct about that. But that doesn't get her where she wants to go in this case, because the statute is silent with respect to the key issue. It doesn't say who has the authority to make the indemnification decision when the governmental agency is a district court. In fact, if you look at the plain language of the statute, it doesn't describe how indemnification is to be accomplished for any of the many governmental agencies to which it applies. All the statute does is lay out the basic framework as to when indemnification is appropriate and when it isn't. It's permitted if the liability is predicated upon an act taken within the course and scope, but not if an employee exceeds those boundaries. So again, the statute gives us the ground rules for determining when indemnification is allowed, but it doesn't say who can exercise the indemnification power. Plaintiff contends we should interpret that silence on the who issue to allow a chief judge to wield veto-proof indemnification power. That's not an appropriate reading because it's inconsistent with decades of law from this court setting forth the separation of powers between the judicial and the legislative branches. Keep in mind that indemnification is nothing more than a funding decision. The sole purpose of it is to require the court to pay a financial obligation that it doesn't own and belongs to somebody else. And under basic separation of powers doctrine, the legislature has the exclusive power to make funding decisions.
Do we know if this was a lump sum budget in Dearborn for the district court or a line item budget?
It's a lump sum budget that consists of dozens and dozens of line items, Your Honor.
That's confusing.
So the court prepares its line, it talks with the administrator of the city and says, this is what we want to do, and then the city gives you a lump sum.
Gives you a lump sum, but
That's how
it's
pretty much every court.
with line item budgets, like I said, dozens and dozens of line items underneath the lump sum, none of which encompass the indemnification policy that's at issue here. Did that answer your question?
Yeah.
Okay.
Counsel, who is responsible if the statute's silent? Who would be responsible for this, answering this question?
The court's funding unit. The court's funding unit, Your Honor, which in this case is the city council for the city of Dearborn.
So
How
you're
would a
arguing,
careful chief judge go about managing risk if he, before, not on the eve of trial, of his
Right.
own trial? Just I just get appointed chief judge of some court, and I want to make sure that I can manage risk appropriately, because I'm trying to, what should I do?
He would do what Judge Summers did in this case after he adopted the indemnification policy, which is consult with the city council and get authority and funding approval for insurance that covers these sorts of risks. And that's exactly what he did. He didn't unilaterally go out and procure insurance. He got authority from the city council to do that.
Once he had the lump sum budget approved, even though to get that approval, you have to give an outline of how you're going to spend the money.
Correct.
And again, not under the pressure of the eve of trial. Had he decided that, indemnification of employees is a good thing, and I can get this from X insurance company for $6,000 a year, and I think I can find $6,000 in our budget. Could he do that without going back to the funding unit and saying, hey, I'm changing things around here?
Yeah, you can shift expenses and expenditures between line items in a budget, but what I'd submit you can't do is go out and procure funding or spend money on something that's entirely outside the boundaries of the budget.
So he didn't have to go back for the insurance. Now let's say the judgment is $10,000. We don't have this fight, right? He can find it in the budget. If he can find it in the budget, it's not a big deal?
No, not if there is no line item for indemnification in the budget. So like I said, you can...
No, I understand, but you just told me you didn't have to have a line item to buy insurance if you could find the money, for the insurance.
No, I'm sorry if I miscommunicated. What I thought I said is that he did specifically get approval from city council for the insurance.
I don't want to know what happened. I'm proposing a hypothetical to you.
Okay.
We're not under the stress of a trial. And he concludes, the chief judge, whoever it is, concludes this is a good idea and goes out and searches for insurance and can find insurance for X number of dollars, $6,000, and says, you know what, our budget has a few things that didn't cost us quite as much. I can find the $6,000 and I want to go buy that insurance. He can buy that insurance without going back to the funding unit and saying, hey, the money that was allocated for this under the budget, I'm going to spend on insurance. Right?
No, I don't think he can do that because it's a discretionary expense that wasn't built into the original
But
budget.
it's not a line item budget, right?
It's a lump sum budget that is approved based upon dozens of line item expenditures that fall underneath the lump sum.
Right, and he's not spending in excess of what was approved in the budget. He's just finding the money to get this insurance. Do you think he still requires approval?
I think it does. And
what is the authority
And
for
here's
that?
the real problem in this case is this isn't $10,000.
Before you
No, you're getting into this
what's
case.
the
I want to
authority?
talk about a hypothetical,
Okay.
okay? What is the authority for saying that with a lump sum budget, he still has to go back and get authority?
The authority is constitutional authority and separation of powers doctrine.
All right, if you want to go to separation of powers, is that a ripe argument right now?
I don't know how it couldn't be. We've raised it all the way through
Well,
from the trial court up to now.
Separation of powers, the party whose authority is actually being separated is the funding unit, right? Not the district court.
Correct.
They're not even a party, are they?
The funding unit is not a party, no.
Okay, and we have litigation or case law, the Crawford County case, that talks about litigation between a court and a funding unit. Is that required? Do we have to get to a Crawford action before we actually have a ripe case in controversy over whether this was properly authorized under a separation of powers argument?
I don't think so, because Crawford talks more broadly about separation of powers, Your Honor. And what it says is that a judge only has the power to appropriate funds, for example, insurance, when it's, quote, necessary to the performance of its statutorily mandated function. Those are the exact words, statutorily mandated. And if you took a look at the indemnification statute, it plainly does not mandate indemnification. It's a discretionary decision. It says that a district court may indemnify its employees, not that it must do so. So it's a discretionary.
So I think we can take judicial notice at what the court's budget is, because it's a matter of public record. And let's say on the first day of the fiscal year, they decide to pay off the judgment, and then 6 months later they don't have the money to pay the employees. Does that create a Crawford problem, because we can't fulfill the essential functions of the court?
It does, and that's the exact problem that this case presents. I mean, clearly.
But now they can't pay employees. What are we going to say?
Close the court?
Close the court, which is the problem presented by unilateral authority of a judge to be able to do this.
Well, all right, I guess that's a double-edged sword. I would think that they could go in and say, we can't pay our employees, the court has to stay open, you have to mandate the funding unit to pay for it.
The only thing the judge can do is fund mandatory obligations. If it's a discretionary expense, he has to go to the funding unit for it. Are we not? I guess.
Well, I am.
Here's the.
Does the city of Dearborn have a written indemnification policy for its employees?
The city of Dearborn?
Yeah.
I don't know the answer to that, Justice McCormick, whether it has one for its own employees. But Justice Czar, let me go back to your question for a minute. Certainly the court has an operating budget, right, that exceeds the amount of the judgment at issue in this case. Its operating budget is more than $1.2 million. But again, that budget consists of all these line items, and not a single one of them authorizes an indemnification expense. If you allow a chief judge to override that by taking funds that are allocated to kind of critical operation expenses, like employee salaries, for example, you're leaving the court unable to fulfill its statutorily mandated functions. And if you could do that, there would be no point to the budgeting process. And just to give you a sense of how that works in this case, the $1.2 million judgment that Judge Summers has sought to indemnify is roughly equivalent to the amount that has been approved by the city for all employee salaries for 2018, which is $1.4 million. And so for that reason, I think it's a very dangerous road to go down.
I want to expand on Justice Zara's hypothetical. Let's say that you get your lump sum budget after having your discussion about your various lines, and then 5 people decide to take retirement. Now you've got this money that was budgeted that you had planned to spend, and now it's available, and let's say the chief judge decides, I want to do this discretionary thing with that money that has been budgeted, but I'm not going to use. Is that appropriate?
Again, I think the Crawford County case still holds that discretionary expenses have to be approved by the court's funding unit. And it's designed to prevent chief judges from spending money on whatever they may like. So I don't think that would be appropriate, Your Honor.
Then what's the difference between a lump sum budget and a line item budget?
Again, I guess we're miscommunicating here. This is a lump sum budget that consists of dozens of line items. If there was no meaning to those line items, there would be no purpose to include them in the budget. The reason those line items are there is to identify how the monies are to be spent.
So there is no difference?
There is no difference
between a line item budget and a lump sum budget?
I would say that this is a line item budget because it's got dozens of line items built in. Let me... For you to prevail, is it a purely separation of powers argument, or can you get there a different way? No, you can get there another way. Separation of powers is a big piece of it. But the other issue is the indemnification statute requires Judge Summers to be acting within the course and scope of his employment in terminating plaintiff. And again, I want to kind of clarify our point of disagreement here. We don't dispute that Judge Summers was able to terminate plaintiff only by exercising power that was given to him as the chief judge of the court. But as a legal matter, I don't think course of employment is a but-for test. It isn't enough to say that an individual used a power that he had by virtue of his employment. The current that runs through the case law cited by both sides is that the individual has to be serving the purposes of his employer and not acting for personal reasons. And I was actually trying to think of a way to illustrate that.
How do you, okay, but here's my question, though. That's a really tough test, isn't it? Because, going back to the question I asked Brother Counsel was, this was a court restructuring. I mean, would this firing have happened if you didn't have the court restructuring requirement? The judge didn't just go and fire this person. There was a restructuring that had to commence. So even though it was not done perhaps correctly, it was still done under that process, was it not?
It was not. The reorganization was, kind of an excuse for the decision to terminate Ms. Pucci. Judge Summers.
But would the defense counsel? I mean, is that something they would stipulate to, or is that your argument?
It was plaintiff's entire theory of the case at trial.
Right. But that's my point. So, I mean, let's just kind of go with the fact that let's just say hypothetically that is. That it was restructuring, the court was kind of going through that. I don't want to relitigate this entire case. Accepting that as true, if you would accept the argument that they were putting forth, that this is under restructuring, then would you still be objecting to it because the judge had to go and do this, but he didn't do it correctly?
If you're accepting the argument, but it wasn't restructuring. That was plaintiff's position at trial in terms of winning the judgment that
no, I
seek to
understand,
indemnify.
No, I don't mean to distract you too much. I'm just trying to get across this point. Let's accept that as real. Let's just create a hypothetical away from this case. There had to be restructuring. We're not accepting whether it was or wasn't in this situation. I don't want to kind of get sidetracked. You had to restructure. The court had a budget. It had to meet the budget. The termination was done in a process that was incorrect or illegal. Then would you have an issue with the indemnification issues that was presented here? Was the judge at that point operating under the scope of their authority if they had to let someone go, but they let them go improperly and in the wrong way?
I don't believe he was, because the reason that he selected Ms. Pucci as the sole employee that was going to be fired was because he had this personal feud with her.
I get that. My question is, let's say that wasn't the case. Let's just simply say the budget had frozen. The court didn't have enough money to operate, so they had to restructure. I'm giving you a whole new hypothetical, not relevant to this case at all. You had an actual restructuring. There was a crisis in the city. There wasn't enough money to go forward. There was a clawback. The issue was there wasn't the necessary funding that was available. The court had to restructure. So the chief judge had to make a determination and say, I have to let someone go. I'm required to do this to keep the building and the lights on. So I'm going to let this person go. They let someone go, but they do it incorrectly. They do it illegally. They break all kinds of employment laws when they do it. At that point, are they operating under the scope of the employment?
But they don't select the employee based on personal reasons.
Let's say he said, I'm getting rid of the old guy.
Right, okay. Let's go with that. I'm getting rid of the old guy because I have to say, I got to get rid of somebody. I'm going to get rid of this guy. Is that part of the scope of the employment?
I think that arguably can be within the scope of employment, but that's not even close to what happens.
No, I understand.
In this
I'm just trying to understand. That would be. So if a judge just does something wrong or inappropriate or maybe illegal in terms of that, you would then concede that that would be under the scope of their employment, that they were operating. They didn't do it right. They didn't do it correct. But they were operating under their scope of employment.
Right. It is outside the scope of employment if they act, though, for personal reasons.
Okay.
And I was actually I was wrestling with this question myself, Justice Bernstein, as I was getting ready for argument today, and actually came up with two hypotheticals that may be a little bit different from yours, but maybe will help put a finer point on this.
Okay.
The first, both of them involve a courtroom bailiff. The first is a bailiff who goes back to a holding cell and sexually assaults a criminal defendant whose case is waiting to be called for hearing, right? That satisfies the kind of but-for inquiry of the scope of employment test because the bailiff was able to access that prisoner, gain control over that prisoner, only because of the power that was given to him by his employer. If he hadn't been a bailiff, he wouldn't have been able to do those things. But the assault in that case was plainly for the bailiff's personal gratification and served no purpose of the court. And so I don't think anyone in this courtroom would argue that that conduct is within the course of employment and subject to indemnification. Contrast that case with the same bailiff who sued for excessive force, this time because he tackled an unruly defendant in a criminal proceeding who tried to approach the bench when he wasn't given permission to do so. In that case, the bailiff may have used the wrong control tactic or gotten too physical with the defendant, but he was essentially attempting to serve the interests of his employer by preventing the defendant from harming anyone in the courtroom, right? And so I think that conduct would satisfy the statutory standard for indemnification. And you were testing me a little bit because there's obviously going to be, gray areas, cases that fall in the gray areas between those two extremes, where it's not quite clear whether someone's acting within the scope of employment, whether they're not. But this case doesn't fall within one of the gray areas. It was entirely personal. As I said, that was plaintiff's entire theory of the case at trial. She repeatedly told the jury that her termination had nothing to do with the reorganization of the court and that everything was personal. And the Sixth Circuit, when it reviewed the verdict, it agreed with her. It found that there was abundant evidence of Judge Summers' animosity toward the plaintiff in the record and held that the jury, quote, considered and rejected the view that the reorganization was Summers' motive in terminating Pucci.
I guess when I hear your hypothetical, what I think of, and just trying to think back to the employment law I used to do, is the first example is a criminal case. There's criminal conduct, and that's why it's not within the scope of the authority. But the other case is a civil matter, and it is within his authority, even if he did it illegally.
Well,
so I'm not quite understanding.
That is a distinction, but one's criminal and one's civil, but they're both personal injury claims, and I think the more operative distinction is that in the former case, the bailiff who sexually assaults the prisoner, he is not acting for any ostensible purpose of the court, whereas in the latter case, the bailiff is. I think that's the critical.
But why isn't a court reorganization within the ostensible purpose, even if it's ultimately found not to be the basis?
Because the theory of the plaintiff at trial was that was a subterfuge. There was no court reorganization. That was just a convenient justification to file Ms. Pucci because Judge Summers had a personal problem with her.
To take your hypothetical that you gave us,
right.
The court officer tackles the defendant before getting to the bench, which every judge appreciates, and then decides, I'm going to give him an extra shot with the butt of my gun because this guy really pissed me off and it's going to make me feel good. Does that take us over to the other side that you described?
I think that's probably getting into one of those gray areas that I talked about, but I think in my view, yes, that would take us over the other side because he's not serving the purpose of his employer and giving him that extra shot with the butt of the gun.
And you're telling us that your case doesn't fall into the gray area because of the way plaintiff presented the case to obtain the verdict?
And because of the Sixth Circuit express finding that she was fired for personal reasons and that it was not as a result of the reorganization of the court. And that's what the jury found as well. I mean, keep in mind that part of the damage award in this case was $200,000 in punitive damages, which required the jury to find under the instructions that Judge Lawson gave that Judge Summers acted with malice or reckless indifference to Ms. Pucci's rights. I don't think a court reorganization is reckless or malicious, but firing an employee because you have a personal feud with her certainly meets that standard. So again, it's the presentation that plaintiff made at the trial court. It's the finding of the evidence by the Sixth Circuit when the verdict was appealed, and it's the verdict itself that includes.
And it's an all or none proposition.
Say that again?
It's an all or none proposition. Because $200,000 was punitive, it spoils the whole verdict.
I think it does. I think it does. Let me talk real quickly, just turn to the Chief Judge rule because that occupied a substantial portion of the briefing as well. And I want to address why that doesn't allow for the indemnification power that Judge Summers adopted either, the indemnification policy rather. The plain language of the rule shows that chief judges only have the limited power to supervise finances through the preparation and presentation of budgets which is subsection C3D. Notice that it doesn't say that judges have the ability to set spending priorities or to impose funding obligations. Instead, I think the fact that chief judges have to present a budget to their funding unit for approval shows that they lack the power to fund whatever discretionary expenses they like. I don't know if that addresses a little bit more the line item question that you were asking me earlier. But I would respectfully submit there's really no other way to interpret that portion of the court rule because, as the city has pointed out in its amicus brief, the court rules can only address matters of procedure. They can't create substantive law. And that's exactly where a plaintiff's approach would lead in this case by reading the chief judge rule to give judges the ability to supersede separation of powers doctrine.
Okay. Are you done?
There are no other questions? I'm done.
Should Dearborn be a party to this litigation?
I don't think it needs to be a party to the litigation because the indemnification policy was never valid in the first instance. Seeking to enforce an indemnification policy that's invalid.
Okay.
Any further questions? Okay, thank you.
Thank you, Your Honor.
Case will be submitted.
Well, you know what? I'll help you out. I'm sorry. I'll help you out. If you want to respond to.
We'll take note that he's the best.
Yeah.
You're all the best. I love you all the same.
That's okay.
You know what, though? But actually, I would like you to respond to the gray area and the hypothetical that I presented and help us to understand when a person exceeds the scope of authority.
Sure. I understood the question as a two-part. One, course of employment. Second, scope of authority.
Yes.
And maybe I'm mixing them up, and I apologize.
That's fine.
And just so I'm real clear, with the court having done the trial and the appeal, is that what the Sixth Circuit actually said was that it was sufficient for the jury to find that simply a motive as part of the reason for the reorganization was this animus, this retaliatory animus. It didn't say that the entire decision was wrong or that the reorganization was exclusively because of animus. That's not what the court said, and that's what we're bound to. I think when we get to course of employment and scope of authority, at least in relationship to the statute that we're talking about, MCL 691-14081, this court has previously said, I think in Petiprin, I always get that case wrong, but I think Petiprin, that subjective intent doesn't really come into play just for this reason, because it's so difficult to discern when someone's intent will remove something that is not criminal, will remove an act or a decision from course of employment or scope of authority. And what makes this case a little bit more clear, I think, is that there is a court rule that specifically prescribes conduct that you can and can't take, right? The chief judge rule specifically tells a judge, you can reorganize, you can restructure, you can terminate. And to simply add to that, in this particular case, Judge Summers sought the counsel of SCAO to do that. He adopted a policy, a restructuring that was conceived of by Judge Foran. So I think to say that this doesn't occur within the course of employment or scope of authority divorces the facts from the case. If there's ever a case where a constitutional violation occurred, it's going to be this one, where it happened in the course of employment and scope of authority. You have a chief judge exercising his powers. Everything happens in the employment setting. It's an employer-employee relationship. All that's clear, which why it leads into, I think, Justice Markman's position or question on Toussaint, which says that the obligation becomes cemented when it's made. And I would argue that certainly if the court wants to say, hey, Judge Summers acted out of self-interest and we don't like that, there was a taint. I understand that on a very human level. But when Judge Wygonik sometime later, with nothing to gain, removes that taint and says, I have nothing to gain here, but as a chief judge, I think it's best for employees that we do indemnify in these situations, under Toussaint, at the time he makes that clear, express, sworn-out promise, the obligation is cemented and it cannot be revoked. And so I would ask the court to reverse. Also, if I can comment on I'm sorry, Your Honor.
Yes, you can comment.
Well, let me ask you something.
Thank you. Yes.
Would you please address opposing counsel's position that the punitive damage award must show that there's malice that takes it outside the scope of employment?
The jury instruction is a bit more fulsome than that. It's simply not malice. It's also reckless disregard of known constitutional rights. And it doesn't remove it from the course of employment. All it does is it allows the jury to make a determination based on what they've seen and heard as whether or not to punish the defendant. It doesn't mean that what the defendant did was not in the course of employment. It does not mean what the defendant did was not within the scope of authority. That's not what punitive damages mean. And the jury instructions didn't require, again, the jury to find that it was malicious. They had to find at least that there was a reckless disregard of these known constitutional rights, which is what they did. Just briefly with Crawford County does provide some guidance to the extent it says that once, and I think for this case, once the court accepts an obligation, if the obligation has to be paid by the funding unit, but the funding unit refuses to pay it, at that point, again, the administrative order, which I believe we spoke about that case, 1998-5, kicks in. And at that point, the dispute as to how it will be paid, who will pay, that is an argument for another day. And maybe that day will come, maybe it won't come. But I believe that the administrative order contemplates just that. Finally, I'd ask that the court just go back to the statute. The statute guides exactly what happens. The statute expressly authorizes governmental agencies to indemnify. We do have a course of employment. We do have scope of authority. We have fulfilled, the court has fulfilled that criteria, and I would ask that the Court of Appeals decision be reversed. Any other questions? I'll be happy to entertain them.
Thank you, Mr. Sklar.
Thank you so much.
Pucci will be submitted.